Firstly, I would like to express my deeply thanks to the organizers for inviting me to this conference. It's a very nice occasion to be here. After many years, I haven't been a long time to Budapest. My field of research is financial law, so I hope I will not boring you with the facts which are in the slides. The presentation concerns with the limits, legislative and judiciary limits for various activities of central banks. Especially it's concentrated on the executing of monetary policy by the National Bank or ECB and the banking regulation and supervision. In my opinion, there are two kinds of limits, national limits and supranational limits, when we are talking about the European Union. The national limits are represented by national legislative acts and national constitution. National acts especially on the status and competencies of the National Bank. And the supranational limits are represented by the European legislation, the Treaty on the Functioning of the European Union, thereafter TFEU, and the Protocol on the Statute of the European System of Central Banks and the ECB, thereafter the statute. Also are represented by the decision-making activity of the European judicial authorities, especially of Court of Justice. Because of lack of time, I will provide only an overview of the first and second part of my presentation, and I will focus on the third part of the presentation, just in a shortcut. The first part of the presentation consists of the substantive Slovak legal limits for the activities of the central bank in Slovakia, so-called National Bank of Slovakia, thereafter NBS, and consists of the European legal limits to the central bank's powers in the EU. These limits are applicable to all national banks which are settled in the area of the European Union, especially in the area of Eurozone. The European legal limits will concern with monetary policy and with financial market supervision, and they especially concerns with the independence of the National Bank of Slovakia or other national banks which are in the EU, and the concerns with the elements of independence which are encouraged in the treaty and in the statute for the ECB. The second part of the presentation is a practical view or assessment of the practice of electronic filling of applications by bank in the case of licensing procedures. These procedures are called SSM procedures, especially the licensing procedures or sanctioning procedures, and under the first pillar of the banking union, which is called the SSM, or the single supervisor mechanism. And the third part of my presentation, which I will focus on, analyze the current legal status of the central bank liability in Slovak Republic for the exercise of public authority when exercising or conducting financial market supervision in a context of recent judgment of Court of Justice of European Union in the case Banka Slovenie from 2022. So, just a brief overview over the legal status of the National Bank of Slovakia. I don't think so we are very interested in this topic, this part of the presentation. The National Bank of Slovakia is encouraged in the Constitution in the Article 56, and it was established by the Act on National Bank of Slovakia, of course, the NBS Act, with effect from 1st of January 1993. What were the prerequisites for the establishment of an independent Slovak central bank? There were two prerequisites: the amendment to the Constitutional Act on the Czechoslovak Federation and the monetary separation, which was on the 8th of February 1993. After this, there were some milestones, legal milestones, for the legal status of the competence of the National Bank of Slovakia. First, it was the adoption of Constitutional Act number 90 from 2001, and which there were some reasons, also judicial reasons, which arises from the activity of Constitutional Court of Slovak Republic. The other milestones were the integration of Slovakia into the European Union in 2004, the adoption of the Act on the introducing of the euro currency in 2007, and the adoption of the Act on the financial market supervision in 2004, with effect from January 2006. In the next slide, I will talk about the independence and the elements of the independence of the ECB, which is applicable also for all national banks in the European Union. Firstly, it should be stated the member state must maintain full compatibility of national legislation with the legal framework of the founding agreements, the treaty and the statute of the ECB and ECB that relates in particular, and I will focus just on the first 2 points, independence of the central bank, which is encouraged in Article 130 of the treaty and Article 7 of the statute, and that relates in particular to compliance with the prohibition of monetary financing, encouraged in Article 123 of the treaty and 124. The independence of ECB, actually the master for the independence of the ECB was the independence, originally the independence of the Deutsche Bundesbank, that was the master, and nowadays the master for independence of national banks in European Union is the independence of the ECB. We know that this independence consists of 4 elements, especially the institutional independence, functional independence, financial independence, and personal independence. I will concentrate later in the third part of the presentation on the financial independence. The elements of the independence have already been the subject of the interpretation of the courts on the supranational level. The Court of Justice of the European Union has stated, has ruled some statements, especially in the case Banka Slovenia, which I will analyze in the third part of the presentation. And also the Constitutional Court of Slovak Republic also marginally addressed some aspects to the NBS independence in connection with the non-appointment of a candidate for a vice governor. It should be stated also that all drafts of national legislation that relate to the competence of the national banks, national central banks, must be subject to an intra-community consultation with the ECB. This is conditio sine qua non, which is sometimes not complied to. The next two slides, I indicate some legislative limits on the EU level and on the national level. You can find it if you are interested in the presentation or in the written form of the contribution, which I will submit to the collection of the proceedings. So, the second part of my presentation analyzes assesses the practice of the cooperation between NBS and the ECB when submitting an application via an electronic system which is called EMAS portal, ECB EMAS portal. ECB EMAS portal is conducted within the framework of the SSM, so within the single supervisory mechanism, the first pillar of the banking union. In this part, I am evaluating the licensing process within this SSM regime because the ECB powers include also various types of licensing proceedings, including also some sanctioning proceedings. The national framework also includes some provisions about this cooperation between NBS and the ECB. It's encouraged in the Act on Banks and the Act of the on the Financial Market Supervision in the Supervision Act. Here is the wording of the mentioned provisions we are interested in. What's the ECB EMAS portal? ECB EMAS portal is an electronic communication system which goal is to simplify, streamline and digitize the process of SSM proceeding and increase transparency in relation to banks about the status of their ongoing SSM proceedings, licensing proceedings, I mean. In this slide you can see the available SSM proceedings through the EMAS portal. In general, it's possible for all banks, significant banks within the SSM framework and less significant banks to submit their applications in these cases of proceedings. A, the proceedings for the granting of approval for the acquisition of a qualified participation. B, proceedings for the granting of a banking license. C, proceedings for the granting of approval for the return of the banking license. Just only for the significant banks are available just two proceedings. Proceedings for the granting of approval for the election of appointment of a member of the statutory body, a shortcut in the personal cases. And the B, which is not very common, proceeding for granting consent to carry out the activity of financial holding company. What's the status in Slovakia? The EMAS portal is in practice used just voluntary, only for submitting personal proposals for the statutory body, supervisory body, and only for the significant banks, not for the less significant banks. But in practice, just one commercial bank, used the system for the personal applications. Actually, it's not very applicable because of some technical problems for smaller banks. What are the suggestions regarding using EMAS portal within the framework of SSM? when the NBS is cooperating with ECB. On the Slovak level, I think it should be mandatory for all the banks, not only for significant, but also for less significant. In the cases of proceedings I mentioned before. The suggestions for the European level are, or regards to the group of the proceedings. I think the group of these proceedings should be more broader. For example, it could include the granting of approval for the merger or for the dissolution of the bank. The last part of the presentation is about liability or responsibility for damage caused by a national central bank in European Union in general, not just in the case of NBS. I assess here I will evaluate the suitability of the liability of the central bank in Slovakia for the exercise of public authority in connection with the case Banka Slovenia. What's the current status of the Slovak law on liability? We have an act on liability for damage caused in exercise of public authority in general, not just only for the central bank. This act is based on the concept, which is common also for Czech Republic, not only for Slovak Republic, and I think maybe also for Hungary or Poland. This concept of liability is built on absolute strict liability. So as you can see, there is no exculpation, yeah? Or no exculpation, no reasons for liberalization are possible. What should we mean under the exercise of public authority? It's every official action or decision making, every decision of the national bank or other public authority concerning rights, legally protected interests, and obligations of natural or legal persons. Under the meaning public authority should be also mean the NBS, so the National Central Bank as well. It's clearly a public authority. The state is liable for damages arising from the unlawful decision or maladministration of central bank. The Liability Act in Section 4 stipulates a list of contact central public bodies, which are public authorities, that act on behalf of the state in the matter of compensation for damage caused by public body. So, as I mentioned before, public authority is also National Bank of Slovakia. She is also included in this list. The scope of proceedings or the scope of acting on behalf of the state also includes the payment of the incurred damage. So I think purposely the law does not use the usual conjunction acts in the name of the state and its account. And there's the problem. As you can see, as I mentioned before, the treaty and the statute of ECB and DCB encouraged also inter alia the financial independence. In Article 123, is stipulated that overdraft facilities or any other type of credit facility shall be prohibited, in a shortcut. The regulation 3060-603 from 93 specifies definitions for prohibitions referred to this article. Inter alia, overdraft facilities means any provision of funds to the public sector resulting or likely to result in a debit balance, or other type of credit facility means any financing of the public sector's obligations vis-à-vis third parties. What was the ruling or the judgment in case Banka Slovenia about? Banka Slovenia brought an action for review of the constitutionality of the Slovenian Banking Act and some other Slovenian act, claiming that the national rules as regards the incurrence of its liability for damage are incompatible with union law, with the treaty and the statute. What stipulated the ruling, the judgment of the Court of Justice of the European Union? There were more preliminary questions, but just in this case is relevant the first one, the answer to the first question, preliminary question. The Article 123, paragraph 1, and the Article 21 of the Protocol of the Statute must be interpreted as not precluding national legislation which provides that the National Central Bank is liable from its own funds for damage only where it or the persons whom it is authorized to act on its behalf acted in serious breach of their duty to exercise due care. What are the doubts, my doubts about the legal status and the concept of liability of central bank in Slovakia? When I'm talking about this judgment of the Court of Justice. Firstly, the problem is that the Slovak Liability Act does not distinguish between the state and the central bank. The central bank as public authority acts on behalf of the act, also including payments for damages. So it has to pay always in all cases of responsibility on behalf of the state, but from its own resources. That's the problem. That this is contrary to the financial independence and the ban of financing of financial sector, which is encouraged in the statute and in the treaty. What are my delegate referenda proposals concerning our national legislation, of course? We have to, in my opinion, we have to change the concept of strict liability, maybe in Czech Republic too, to one of relatively liability. So maybe like they did so in the case of Central Bank of Latvia, according to the ECB opinion on the reform of the Latvia's Banka. B, there's some another solution to the problem. The B problem is that NBS will always have to pay for the damage from its resources. The referenda proposal is to make the revenues from all fines which are imposed when exercising financial market supervision, to make these revenues from all fines to be revenues of the NBS, or to introduce a mechanism whereby the state would pay for the damages incurred if the NBS was acting. The conclusion, and that's the conclusion of the third part, and that's a conclusion of the presentation as a whole. I think the Slovak concept of liability is contrary to the prohibition of the monetary financing of the public sector and the financial independence of the National Bank of Slovakia. Thank you very much.